Jacob Chansley, the Qanon Shaman, has attempted to vacate his guilty plea and essentially wants a redo in his case. This was denied. Now, there are some things we're talking about in this specifically. We're going to skip over the background section and actually go to page 17. If you want all of this, it'll be in the pinned comment. So we have him concocts a Brady claim, a derivative of ineffective assistance of counsel, based on videos aired devoid of context and supposedly inconsistent disclosure dates provided by the government counsel in two separate cases. These videos are decidedly not exculpatory, especially when viewed in context with the miles and miles and miles of footage recorded of Mr. Chansley on January 6, 2021. Such footage conveniently omitted by the March 6th program, which I believe this is Tucker Carlson before he got fired, shows nearly all of Mr. Chansley's actions that day, including carrying a 6-foot-long pole armed with a spearhead, unlawfully entering the Capitol through a broken door, disobeying orders from law enforcement on more than a half-dozen occasions, screaming obscenities, entering the Senate chamber, climbing onto the Senate dais, sitting in the vice president's chair, leaving a threatening message for the vice president. Moreover, the precise date that the particular videos appearing in the program were disclosed is immaterial because Mr. Chansley and plea counsel were aware of the video's content. Mr. Chansley's interacting with law enforcement officers who did not visibly impede his progress by May 20th, 2021. So this wasn't new. In other words, Mr. Chansley possessed the facts in the videos well in advance of his plea agreement, yet still determined, quite sensibly, to accept responsibility for his role in the criminal act of January 6th. What is more, the record shows that the government disclosed virtually all of the videos at issues weeks before Mr. Chansley's sentencing. These facts and the underlying law conclusively demonstrate that Mr. Chansley is not entitled to relief under 2255. So here they're just saying that his claims are timely, not waived, not moot. As a threshold matter, Mr. Chansley claims are not time barred under the Anti-Terrorism and Effective Death Penalty Act, blah, blah. So basically saying he can make these arguments, but more information about the type of arguments, when they can be made. But his actual argument itself is without merit. Even though Mr. Chansley may assert his Brady claim, he does not meet his burden to show that he's entitled to relief on that basis. He argues that the government violated its obligation under Brady, therefore secured an unconstitutional sentence by not disclosing the videos broadcast on March 6, 2023. Mr. Chansley's argument in its various permutations is believed by the court, applicable law, or belied by the record, applicable law, or both. Nearly all the videos at issue were disclosed with the defense. Television program also discussed Mr. Chansley's time on the Senate floor. The record demonstrates that the footage depicting these events recorded by the New Yorker was disclosed to plea counsel on April 24, 2021. So it's basically just tearing apart everything he was claiming involving the Tucker Carlson thing and those videos. None of the videos are exculpatory. A lot more on that. Just basically going into details here. Mr. Chansley cites the government's first September 17, 2021 discovery update in the two district court cases referred to in a foot herein as evidence that the government's approach to discovery does not adhere. And this is a lot of just legal jargon you can go through if you'd want to look it up to fully understand it. But they're saying his argument misses the mark. The government cited those cases merely for the proposition that defendants are in a better position to determine what evidence they believe is exculpatory and will help their defense than the government. So it did not go well. More about the Brady stuff. Mr. Chansley's ineffective assistance of counsel argument is without merit. Despite his repeated assertions, he was satisfied with the plea counsel in writing and on the record. Mr. Chansley now argues that plea counsel was ineffective in two ways: by encouraging him to accept a plea agreement containing a sentencing enhancement and appeal waivers, and two, by not demanding production of the CCTV videos aired during the March 6, 2023 program prior to the sentencing in order to use such video at sentencing. He claims that he suffered prejudice because absent these errors, he would have received a more favorable plea agreement and the court would have imposed a lower sentence. His argument is wildly speculative, contrary to established case law and practice, and devoid of common sense. I had to make sure I put the devoid of common sense in there. Mr. Chansley has not demonstrated that plea counsel performance was deficient. We just continue on more and more and more and more and more. He has not demonstrated he suffered any prejudice. Continuing on. Mr. Chansley's claims are without merit, thus the court will deny his motion to vacate, set aside, or correct his conviction. The court is disappointed to learn that through this filing and public statements, Mr. Chansley has recanted the contrition displayed at his sentencing hearing nearing 2 years ago. Such an about-face casts serious doubts on the veracity of any of Mr. Chansley's claims here or where else. Finally, the court would be remiss if it did not address the ill-advised television program of March 6th. Not only was the broadcast replete with misstatements and misrepresentations regarding the events of January 6th, too numerous to count, the host explicitly questioned the integrity of this court, not to mention the legitimacy of the entire U.S. criminal justice system, with inflammatory characterizations of cherry-picked videos stripped of their proper context. In doing so, he called on his followers to reject the evidence of their eyes and ears. Language resembling the destructive, misguided rhetoric and fueled the events of January 6th in the first place. The court finds it is alarming that the host's viewers throughout the nation so readily heeded his command, but this court cannot and will not reject the evidence before it, nor should the public. Members of the public who are concerned about the evidence represented in Mr. Chansley's case and others alike may view the public docket and even attend court proceedings in these cases. Those of us who have presided over dozens of these cases arising from, listened to, and hundreds of hours of testimony describing and reviewed thousands of pages of briefings about the attack on our democracy of January 6th, knew all too well that neither the events of that day nor any particular defendant's involvement can be fully captured in a seconds-long video, carelessly or perhaps even cynically aired in a television statement or attached to a tweet. Before appealing a final order denying a 2255 motion, a court must issue or deny a certificate of appealability. The defendant may not appeal without a certificate of appealability, and it just continues on. For the conclusions that Mr. Chansley's motion, the record of this case, do not show the entitlement to relief, no evidentiary hearing is warranted. The court will deny Mr. Chansley's motion. No certificate of appealability shall issue. A separate order consistent with memorandum shall issue. And I didn't read it off. It's somewhere in there where they also state that due to him recanting, if they were to redo his trial, it's most likely he's going to get a longer sentence. Which is honestly why I was kind of hoping they would accept it. Because wouldn't that have been interesting? Imagine asking for a redo and getting yourself a worse sentence. But yeah, directly calls out Tucker Carlson's program. And Tucker Carlson as the host. Pretty interesting. I'll have it in the pinned comment for you if you'd like to read it yourself all the way through.